would be Mr. Vinayak from Bajaj Electricals, who brings in 18 years of IPR experience specializing in filings, litigation and IPR management. His training with Indian and Japanese patent offices highlights his expertise. We welcome you, sir. Joining him, we have an exceptional lineup of speakers. Firstly, we have Mr. Aditya Patil from Polaris Inc. He leads patent operations at their Bangalore center with 13 plus years of experience in IP lifecycle management. He is a registered patent agent and promotes IP awareness through university sessions. Welcome, sir. Now, let's welcome Mr. Biju K. Nair from Open Innovation Network. As the founding partner of the Tech, Mr. Nair specializes in open source compliance, advising global projects, mentoring startups, and enforcing licenses in India. His contribution to technology law is invaluable. Welcome, sir. Lastly, we welcome Ms. Taruna Gupta from TCS, a seasoned professional with 28 years of experience in the IT domain. She leads TCS's corporate IP and engineering, specializes in IP governance, risk management, global collaborations, ensuring innovation and strategic alignment across industries. We welcome you, ma'am. And now I'd like to hand over the session to Mr. Vinayak, Managing IP Risk and Mitigation. Thank you.
Hello. So, good afternoon all. Welcome to all for the 12th technical session on managing IP risk and mitigation. So, what we want to do, we will have the two sessions, two rounds of discussion amongst us. After that, the panel will be open for the questions. So, I request all of you to have as many questions thrown at us, so that we can do justice with our time and your time as well. So, yeah, excuse me? Excuse me? Can you please sit? Okay. So, when we talk about the IP risk, so generally people think of the only two types of risks. One is like if you are infringing somebody else's patent, or your patent being infringed by somebody else. But according to me, IP risk is a very broader concept. Like from the start of the project, start of any R&D project to the till management of your portfolio, at every stage you have a particular risk. Like suppose you start a project, any R&D project. So the first risk is that whether you are reinventing the same thing. So what you have to do, you have to see what is the technology landscape of that particular technology. What is the IP landscape of that technology? What is the competitive analysis with respect to that technology? So once you see all those things, then you can decide what is your R&D project or next project is going to be. So that's the first risk you need to manage. Second risk, what I thought that once you get your project, what project you are going to doing. So in that project, what are the probable patents you can file? So in that case, then you can do a prior search with respect to each of those inventions, and then you find out like, okay, so which out of these, all these inventions, which is patentable one and which is not patentable one. So that is the second risk you can mitigate. The third part is like, now your project is at a particular level of maturity. Like suppose it's at a testing level it is there, or you have made a proto of this. So now the third risk you have to manage is that whether you can really, whether you have a freedom to operate that particular say part or particular component in a particular market. So that's a freedom to operate search or freedom to operate analysis you need to do. So once you do that, then you will come to know whether you have a freedom. If don't have a freedom, so that is the only stage where you can change the design of your product. And otherwise, if changing of the design is not possible, then you can invalidate that particular patent, which is the bone of contention. If that is also not possible, then you can simply take an assignment from or a license from the particular patent holder. So after that, the fourth risk and managing that is that, okay, now I have a say 10 number of prior such as come positive to me. So whether all 10 I need to file it. So whether there is any sense in filing all those patents, because filing a patent is a different thing, but whether there is a really use of those patents. Like it should not happen I file a patent and after 1.5 years I am going to discard those patents because I have to pay the renewal fee, I have to do so many things with respect to that patent. So that also you need to see. So once you file a patent application, then you have to see like now the product is a market. You protected the particular IP. Now the next stage is like now you have to again do the competitor analysis, similar product watch to see whether similar product is being in the market, whether somebody is already selling a certain similar product in the market. So that you have to check, and that is also you can manage your risk. And the last one, you have an entire range of portfolio with you. So now you have to see which are the patents or the IP are redundant one. So like there are certain technologies is become absolute after a certain point of time. So now as you say there is a fast moving technology. Suppose one technology is valid now, but after say 1 and 2 years it will become obsolete. And you cannot do anything with that. So then you have to discard those patents and don't pay the renewal fees. So that is another way of the managing the risk. So this is the way I think it's a comprehensive way you can manage the risk necessity with the IPR protection. But this is the thing which I have told about the basically what are the various risks and how to manage it. But there are certain risks associated with the supply chain management with respect to your vendor dealer relationship. So how to do that? So I will come to my next co-panelist Aditya to dwell on this topic more.
Hello. Yeah. Thanks, Vinayak. Happy to be a part of this GIPC session with the stalwarts sitting right next to me. And you laid a nice background of what exactly IP risk could be and how exactly that could arise. So probably out of my experience in automotive field for maybe 7-8 years, I would mostly be touching upon the specific point about IP risks that get involved in the supply chain management. So I believe that the automotive industry is going through a shift. So we were thinking of mechanical or purely automotive engineering, but now there's a complete shift from these particular core technologies to what we call it as software developed vehicles, then connected vehicles, then probably Industry 4.0. So these are the terminologies that we have been hearing for maybe 5-7 years now. And with the evolvement of these particular technologies and with the penetration of these particular technologies into automotive domain, the automotive industry, specifically OEMs, need to depend on the suppliers to get the resources delivered to them. Because at this particular moment, I'm 100% sure that no OEM can say that no, I'll be self-reliant on getting these things done in-house, like software development, then communication protocols and everything. So the need arises wherein OEMs have to largely depend on the sources, not just the commodity manufacturer, not just the commodity part manufacturers, but the service providers as well, and the companies or the maybe contract manufacturers who deal into this particular area. So there's a lot of JVs happening, joint ventures, a lot of collaborations with the R&D teams and universities happening with the OEMs, and there are a lot of complexities that get involved with these particular JVs and collaborations. So what are some factors that affect these types of collaboration? So there are a few pointers that I could collect. So first basic is the infringement of your IP. So supplier knowingly or unknowingly might infringe any third party's patent while supplying that particular commodity or maybe a service to you. So that is the one biggest risk. Specifically talking about the suppliers, tier 1 suppliers, tier 2 suppliers in India, generally what I've seen is, what I've observed is, they lack in knowledge, they lack about the knowledge of IP, first of all. There are IP agreements are in place, but those are drafted pretty loosely. That is the first thing. And IP audits and such checks are not pretty much followed in this tier 1, tier 2 companies. So that is why these risks arise out of the collaboration with such companies. So that is first thing. And then there is simultaneously threat of trade secret leakage as well. So generally what I've seen is whenever our designers send any of the design or any of the problem statements to these particular companies, contract companies, there is always a risk that such designs get leaked to a competitor through this particular suppliers or top like tier 2 manufacturers. So this is again a second parameter of the risk that I could touch upon. Maybe third, I will talk about brand protection risk. There is always a risk of getting counterfeit products delivered to your end. So, and maybe non-compliance licensing, like whatever licenses that you draft and whatever the agreements that you draft between the company and OEM, there's always a risk that that particular supplier, knowingly or unknowingly, breaches the terms of that particular contract or maybe a license. And I have an example to tell you. When I was serving my last OEM, that time I think we had designed something on our own, and on top of that we wanted some component to sit on that particular component that we had designed, and we requested our supplier to go about or maybe invent about that particular component which was already existing, and we shared some of the designs which were a property of us, and we got that supplied from that particular tier 1 company for maybe a couple of years or 3 years, and because of some issues regarding the price or the price of that particular component, we had to look after the second supplier for the same component, and ultimately we stopped buying anything from that particular supplier number A, supplier number 1, and we started sourcing the same component from supplier number 2. Eventually what happened, supplier number 1 got to know about this particular arrangement that we did, and he went into the court filing a suit against again the second supplier, and we were also a party to that particular litigation suit. So eventually it came to IP team, and when we checked what exactly has went wrong from OEM side, we saw that all the designs were a proprietary, like we had an ownership on that particular part or a design which we had shared with company number 1. They built something on it, they tested it, and without knowing our OEM, they filed a patent application on it. And eventually we were being asked to stop that particular supply from number 2. So it is a big learning for our OEM that time, that without any particular IP clauses in place, I think we should not go ahead and then share any designs with any supplier company. I'll take a pause here because I have spoken about the risk. Maybe in the second leg of this particular discussion, probably I'll touch upon how exactly this risk could be mitigated.
Thank you, Aditya. So now, as all of you know, like open source is a very big thing nowadays. So at some part or every organization, something related to open source we do. We use the open source for developing something over it. So what are the risks associated with the open source and how it can be mitigated? So Biju can throw light on that.
So my colleague had already talked about the risk from in the automotive space, both from vendors, both from the perspective of third-party service providers, and in the whole supply chain, like post-COVID or even pre-COVID, there's a global supply chain. We all remember, there was no automobile we could purchase because there was a chip shortage. So all those issues, can it be solved? So what are the risks? So some of the risk you talked about is the internal risk from the employees. So one way of looking at it is also your internal employees, how do you educate them? So are there global best practices? So for example, for open source compliance, there is a global best practices which is now an ISO standard. It is called the Open Chain 2.1 specification, which is an ISO standard now. So companies across the globe, vendors of all sizes can do self-compliance because the standards are set. So what are the standards? Basically, it leads to having a training, having an open source policy in the company. Who need to be doing compliance? Typically, it is the IP team which is put the onus of doing the compliance. But in this ecosystem, what happens is at each level there is compliance happening, because the second any team is using any code, they have to check it at their level and whether it is complying with the open source policy of the company. So after this happens, before the product is shipped to the market, there has to be a check again. Because what happens typically is there is a lot of pressure on the development team to push the product into the market. But what happens if you don't take these steps? So first step is educating your team, both technical team and the other teams. Because your sales and marketing team also should know this. Because if there is an inquiry about your product, what is the license your product is under? Which open source license? The sales and marketing team is clueless. What is this question? I did not know this. So your sales and marketing team, your IP team, your engineering team, all have to work like a one unit. So training, compliance, you should have an open source policy so that every member in the team, because every company in the world has new employees coming in and they will say, I don't know this. So as part of their initial induction itself, you should have this training. And it's not just open source, it should be the basic IP, because they come from an engineering background. They may not be taught about IP. So it is very important that training, open source policy. So through this Open Chain 2.1, which is an ISO standard, all this can be done internally. Training material is there. If you are a smaller entity, there is a special scheme of things where you can adopt that. If you are a bigger company, you have a separate documentation, so you can adopt that. And you can curate yourself. Like in some companies, you don't have a CTO designation, but you have an engineering team. So that process can be divided in the way you want it. But fundamentally, the process is the same. The objective is the same, that you are checklisting. Because today in the ecosystem, it is not just your competitor who can sue you. It can also be your user who can sue you. You can be stopped, your product can be stopped through the customs authority to be shipped into a country. Like there are provisions under the Customs Act in India, US, across the globe. So there are various ramifications. Your distributor can be sued. We have seen cases where Chinese manufacturer distributed by a German entity. The German entity distributor was stopped by the court. So, and there are like copyright trolls. There are patent trolls. So it's not just the patent part. So it is not just your vendor. So how do you do this compliance on the license part? Because a lot of entities don't understand the implication of licensing. Like during COVID times, I had an opportunity to enforce a GPL license against various banks and financial institutions in India, because they were clueless. They thought that the vendors had the obligation, but it is end of the day you are shipping that product. It might be done by a vendor, it might be done by a system integrator, it could be done by anybody, but final product is yours. So it is very important that you should understand the implications. As I told you earlier, your products could be stopped from shipping because there is an IP violation there. Your competitor could sue you. Like the best case was Cokinetics versus Panasonic, where the competitor sued them because the other party had not done open source compliance and shipped the product faster to the market. So they said that they have shipped the product faster to the market because they have not done open source compliance. And they claimed $100 million US. That is the amount of claim. So it is very important. The other issue which I have commonly seen is during merger and acquisition. Today, every entity has software, whether it is automobile sector, whether it is your app. In one form or the other, you are acquiring or buying or selling software. And there is no open source risk analysis or an audit. So I can give you an example of Cisco. Cisco bought a company called Linksys. They did not look into the GPL component in that purchase, merger and acquisition. And we are all aware that Cisco would do a good job, their lawyers would do a good job, but they did not look into the open source compliance. And there was GPL found. So Cisco was sued in New York District Court for non-compliance. And the sad part is that if you are sued or you got a cease and desist notice, the end result is you have to still do compliance. So your stock goes for a toss, you have to do compliance, you have to redo the software. So there is no point of putting pressure on your development team to push the product to the market. So merger and acquisition at every level, like by any procurement team, sales team, marketing team, IP team, legal team, every engineering team, everybody has to be involved. It can't be, oh, the bug stops at the IP team or the legal team. We are not responsible. But the share price of the company goes down. So that is the consequence. So in this round, I will talk about the risk. I will talk about the mitigation methodology in the, I think, next round.
Yeah, thank you, Biju, for you focus on the 2 points, like one, compliance and the awareness. So now we will see what is the role of policy and governance on this part. So over to you, Taruna.
Yeah, thank you, Vinayak. Pleasure meeting all of you. While I'm representing TCS and the Tata Group, the views that I plan to share here are very representative of the entire software industry. Each of us as an organization, we work with many entities in the ecosystem. We work with our customers, we work with our partners, we work with our suppliers. So it's a very integrated ecosystem. And as Biju and my other co-panelists mentioned, any particular risk could expose your entire ecosystem, and the weakest link in that entire ecosystem could expose you to a lot of reputational damage, to a lot of financial liabilities and many more repercussions. So how do we keep ourselves safe? At the very onset, each of us has to understand, as Biju also mentioned, that every employee has a role to play. And how do we ensure that every employee is informed about the do's and don'ts? What are the guardrails that the organization has published? What are the policy controls that are already in place? What are the areas of improvement? And how does this journey continue? A lot of us deal with roles in the organization. On one side, we talk to the inventors who are coming out with innovations and who we are in touch with for protecting IP. That is one angle. We are also in touch with product owners, solution owners. We are in touch with employees who are customer facing. And in this entire ecosystem, we are dealing with IP of various forms. We are dealing with IP that we own as an organization. We are dealing with IP that is licensed to us by our customers and suppliers. And whether it is in the Indian geography, whether it is across the globe, across the continents, we know that there are many touch points. And our associates or our employees who are customer facing, let's say that a particular customer wants us to implement SAP, for example, or a particular customer wants us to develop their in-house product. The license controls, the licenses that we inherit by way of the agreement, by way of what is mentioned in the master services agreement, what is mentioned in the SOW, states very clearly what is the license that has been made available to us. And then how do we ensure that the person who has been allocated to the project, how does he or she make sure that he is using that particular software for a stated purpose. For example, in a project, we have developers, we have testers, we have business analysts. Does everybody need access to everything? Does everybody need to access a particular software for the same purpose? So what we do is, when we induct people into the projects, one, we make them aware that you have a certain role to play. You are going to be in possession of certain confidential information that the customer is going to share with you. For example, the customer's business knowledge that has been given to the developer or the tester for the purpose of, one, understanding the product, the functionality, but is that person then allowed to share that information with his colleagues or with somebody else in the organization? The answer is no. So what we would like to do and what we put in practice is that we publish something called a Ready Reckoner. And in the Ready Reckoner, not only the open source and the third-party license obligations, the understanding of what is sitting in the master services agreement or the SOW. Sometimes there are contractual obligations. A customer may say that, let's say that's a US financial customer. The agreement might say that if you have a person from a service provider organization that is working on that particular customer engagement, he or she should not move to the competitor of that particular customer, because they may take that knowledge to the other competitor. That is not warranted. Similarly, when they give us licenses, can the license be used for read-only purpose? Can the license be used for modification purpose? And so on and so forth. So there are software license restrictions. Now the third aspect is, in any large organization, it is always possible that one is dealing with one's own IP and one is dealing with partner IP, and at some points there could be a competition between these two. How do you create a Chinese wall, and how do you have the right ring fencing measures in place to keep these two walls distinct? You could have infra-related restrictions, you could have firewalls, you could have email groups which prevent a person from communicating to another part of the organization where such competition exists. So these are just some of the controls that I'm talking about. Let's hear again from all the panelists and we'll deep dive further.
Yeah, thank you, Taruna. So when we talk about the IPR risks, so the biggest risk is like we are going to have a litigation sometime. So like, can we manage that also? So I will give my perspective like as an in-house counsel or attorney. Like whenever any litigation, there is a chance or possibility of happening any litigation, we have to see whether is it the only option left with us. So whether there are any other options, can it be done by sending a legal notice? Can it be like, is there any other option we can do except the litigation? Any litigation also not necessary every time you have to fight a case, like even the court, the case has gone to litigation. Whether there is a like, as of now every court says for the mediation. So whether mediation is a good option, you have to think, because court is very liberal to give you the time for the mediations. So in that, and another thing what I found, like generally judges give you a hint. So which way the wind is blowing. So can you sense those wind, and then based on that you can manage or you strategize litigation in a further way. So those are also the things which you need to think whenever there is litigation or managing your risk related to the litigation. So now we will go to the next round, and like as you said, now you will go to the mitigation of the software related risk.
Before I go into that, I would ask all of you, I'll give you a situation. You please answer which way you would go for that. So your company has been getting a contract from a Middle East client for a software. And this is a global software company. As a salesperson, obviously you will sell it to the Middle East person, entity, because your company makes a lot of money in that software sale. But there is something called the export control. That's also one risk which companies have faced. And unintentionally, if the software is sold in a controlled country, which in Middle East also there are many countries across the globe. We have many countries now. post the Russia-Ukraine issue, or before that also. So, in a typical risk situation, you would not look at export control as an issue itself. But as an entity which is selling that software, you have to look into what is the possible usage and misuse of that software by a neighboring country also. So, in this case, finally, the entity did not sell the software to that region itself. Because the risk, the immediate gain is there, but the long-term risk is higher than the gain. So it is very difficult to do business, with all those risks which is unseen in the initial stage. Because it is very difficult for the sales and marketing team to understand, okay, the implication of this sale. So moving from that to the risk mitigation. So for open source license management, as I told you, there is a global ISO standard coming from the Open Chain, which is a Linux Foundation project. And there you can do a self-assessment. So you also have an option of third-party assessment by agencies across the globe. But that gives you an edge. And irrespective of the size of the company, you are a small company, big company, medium company, there is, playbook around that. Not just for license compliance, even for open source compliance. So from that perspective, there is a risk mitigation methodology. And these are the global best practices. So it's not just one company from one region or one sectoral company like automotive companies. It is being adopted by across the globe. Even like entities like National Health Scheme of UK is adopted it. So it's not just the private sector, it is the government sector also which is adopted it. So that's one sector. The other is the risk. When we look at patent risk, we always think of an offensive strategy. Do we have a defensive strategy? Not just for companies, non-profits, smaller entities, startups. Because see, bigger entities have the financial wherewithal to fight back. They will have a legal team across the globe. They can do that. But if you're a smaller entity, you are a non-profit, you are a startup, do you have and the risk today is much bigger. With the advent of use of AI, I think all of us would see a lot of litigations more, because with the advent of use of AI for coding and stuff, there is no license compliance. There is no look at what is the code coming from. Like if it was a code which was written 10 years back, you know which team would have done it. But you don't know today where this code came from. Who put that piece of code. So there is a need for software bill of material. So what is a software bill of material? If you buy a cookie today, you know the ingredient list. A software bill of material is an ingredient list. What is there in that software? What is the license? What is the version? Which software, which code, which library, where it was taken. So that there are various implications of this software bill of material. What are the implications? Cyber security. There are been instances like Equifax case where software was used, there was a patch because there was a vulnerability detected, there was a patch released by the foundation. That patch was not fixed. Because of that patch not being fixed, there was a huge data breach. Now you can understand with the advent of data protection law across the globe, what would be the implication of the data breach on the entity. So Equifax faces this problem. The other usage is from license compliance management. Because you have a software bill of material, you can do a license compliance. So even in India, the CERT, which is the Computer Emergency Response Team, has come out with the guidelines. SEBI, the Security Exchange Board of India, has mandated software bill of material for any regulated entity to be done by, it was initially January 31st, 2025, the timeline. Now it has been extended to March 31st, 2025 because the industry is not ready to adopt it, because for them it was a shock. Oh, what is software bill of material? So across the globe, it's not just India. The post-COVID, by an executive order, Biden administration made software bill of material for any procurement by US government entity. Software bill of material is a mandate. Europe also, CRA guidelines also makes it mandatory. So across, even in Japan, there are certain legislations. So across the domain, across sectors, then there are sectoral regulations. Like in the fintech space, I've already talked about the SEBI requirement. So software bill of material is one requirement. Now let's look into the patent risk and how do we mitigate it. So I represent two global communities. One is called Open Invention Network. We have been, as a community, we have been functioning for last 21 years, where we try to mitigate the risk around patent entry created by two types of entities. One, an operating entity which has patents, also created by patent trolls. As you are aware, patent trolls or non-practicing entities create a havoc to the whole ecosystem. So they buy patents and sue companies left, right, center. And in many cases, what we have seen is there is no actual infringement, because companies, it is cheaper to pay up the patent troll initially, but you realize later on that if you pay up to one patent troll, you are a low-hanging fruit. So, every patent troll in the world will be after you. So it is, in the short run, you will think that, okay, it's cheaper to not pay my lawyer and it's expensive, I'll pay the patent troll. But in the long run, many companies have understood that, it doesn't make sense to pay the patent trolls. So what is the way out? OI ensures that on Linux and open source, being fundamental technology, if you're part of the community, you join the community through an e-license. There is no cost or commercials being part of the community. The only obligation you have is, in case you have a Linux platform patents. To my understanding, most of them are users of Linux and open source. They don't have patents on Linux and open source. So even assuming you have a patent on Linux and open source, the benefit, reciprocal benefit you get from the community is far outweighing the patents you have on Linux and open source. So this is a global community. So the license is a global license. And as I said earlier, there is no cost. And it is across sectors. Companies and startups and projects across the globe have been part of this community. And as I told you, how do we make sure that there is no risk from operating entities in this community? We have patents in all areas of technology, so that in case a patent troll sues you, an operating entity sues you, we have patents which we can give you so that you can retaliate. So we create a level playing field for you. In case you are sued by a patent troll, we provide you a prior. So that's how Open Invention Network helps you in mitigating the risk. So this is a defensive strategy, not an offensive strategy. And it's a very cost-effective strategy. And it's a global strategy. Unlike a patent filing which is jurisdictional, this is a global strategy you can have. And irrespective of your size, as I said, you might be an open source project or you are a non-profit, anybody you can join the community. The other community I represent is called LOT. LOT stands for License on Transfer. So what happens here is, typically patent trolls buy their patents from operating entities when they sell it. Like recently, VMware was bought by Broadcom. So when Broadcom buys VMware, there is tons of patents which VMware has. Many of them which will not be useful for Broadcom because they are not in that domain. So Broadcom would typically sell this. And these patents are generally bought by patent trolls. So if you look at the background of patent trolls, they are generally funded by either a VC firm like SoftBank has a patent troll called as Fortress Investments. In different names they have it. Intellect Ventures is one big patent troll across the globe. Sovereign funds are also funders of patent trolls today. So it's a very interesting thing. And SoftBank also is an investor into most of the startup ecosystem across the globe. So it's a very unique thing. So how does LOT helps you is, if you are a LOT member and any LOT member has sold those patents and it is bought by a patent troll. So we define a patent troll in LOT as anybody who is making more than 25 million, more than 50% of their annual revenue from filing patent infringement cases. Because there have been many entities, on the face of it they will be a software entity, but their actual work is being a patent troll. So to overcome that, so any entity which makes more than 50% of their annual revenue as regards to LOT is a patent troll. So if that entity buys any of the patents of a LOT member, they cannot use it against another LOT member. So we are keeping millions of patents away from the hands of these patent trolls. So both are defensive patent strategies. In OI, irrespective of your size, there is no cost. Here, if you are making more than 25 million US dollars annual revenue, there is a cost. Bigger companies can pay, smaller companies, and the cost is obviously, quite cheaper than paying the patent trolls. So both are defensive patent strategies. Yeah. So I think with that.
So we have less time left. So any last comment from you? Firstly Taruna, then Aditya. Then we can open the forum for the question and answer.
Yeah, so recapping what this panel was presenting, I think what I'd like to leave the audience with is there are two parts of the spectrum. One is connecting the dots and building traceability of information at every hop in the journey. And two, making sure that we have the right audit checks to uncover what is a possible leakage point. And whether from an open source or a license compliance standpoint, whether from a product shaping standpoint, whether from the right access and right usage principles of any IP, whether customer, third party or whatever else, if we continue to keep that audit process on, continue to inform all our stakeholders that this is where the audit leakages are happening, leakages that are discovered by audit obviously. These are the areas of improvement, whether in the product shaping strategy or the product using strategy. And the entire endeavor that we are working towards is to be able to build a trustworthy ecosystem so that every entity that transacts business with us is assured that their IP is safe with us.
Okay, so in the paucity of the time, I think quick 3 points I would like to mention to overcome or to mitigate the risk with respect to the supply chain issues. So first is again, which you mentioned about the awareness that has been created within your team, like whether it is an engineering team, design team, or whether it is a procurement team. They should be aware what exactly has to be a part of the IP agreement that is signed with the supplier company. Again, you can take a liberty to create awareness at the supplier side, because in my opinion, I think whenever it comes to tier 2, tier 3 suppliers from India, I think they lack knowledge about the IP and how exactly the IP agreement should be dealt with. So that is the first part. The second part is again the supplier waiting and maybe supplier check. So you can see whether the product that is being delivered by the supplier to you is really not infringing anybody else's or third party's patent application or any other IP for that matter. You can do FTO on your own. You can ask FTO checks to be done at your supplier end. So that is the second thing. The third thing again, Biju, you touched upon that part of agreements. So agreements, they should be customized. Like there's no single agreement that fits all or fits everything. So you mentioned about OSS as well. So specifically talking about the automotive sector, OSS was not a part of that particular IP agreement. But now this is the time that automotive companies should start looking into framing a clause around that particular OSS in their IP agreement. So that is one thing. There should be a regular checks about how exactly this IP agreement can evolve around the period of time, like over the period of time, because particularly like one particular supplier is supplying to you over the period of time, but like over the period of time it may not suffice, like the clause may not suffice the protection that you need. So again, the regular revisiting that particular IP agreement at a frequent intervals. So I think with that, these 3-4 points, I would like to stop here and thank you so much.
So we can have some 2-3 questions. Yes.
Hi, Biju, you mentioned that in an M&A transaction, you need to do a open source audit slash diligence. Now, while I'm aware that in asset acquisitions, software agreements, software assignment agreements, this is already happening in India. But don't you feel that this is quite onerous when it comes to an M&A transaction? Because literally, you're looking at acquiring a company or acquiring a business where there could be thousands of software, and parties would typically rely on reps and warranties backed by indemnities. So, do you think this is something which is happening overseas? Is it not happening in India? And what do you think is the middle path? Because I just feel prima facie that it's quite onerous.
Yeah. So you are absolutely right, because you do a merger and acquisition in a time-bound manner. But as I gave you an example, you would pay a huge price, and let's say you understood that there is a GPL component, and you can't sell it as a proprietary software, as in the case of linkages. That's why I gave that example. So if you know at least I understand you can't do the complete code audit because even the seller will not give you access to that. But you can do some basic work of asking whether you have an open source policy, and can you give us a sample of your code base, because then you can understand the extent of non-compliance. It's like in a bunch of grapes, you can even pick one grape, understand the quality of the grape. The same logic applies here. Because I understand it's a time-bound merger and acquisition. They may not give you the code base because that's their IP, and there is lack of resources also to do this audit. There is a cost to that. So asking some basic questions: do you have an open source policy? What has been can they give us? Because that also shows their readiness and willingness to share some sort of their sample, code base, and have they contributed to open source projects. So all these things, like I can think of multiple ways, not even without touching their code base itself. I can think of questions, if they can answer, it will give some sort of a security, and put a clause that the payment, the remaining payment, would be subject to a compliance check. Because otherwise you would pay a huge price, and you would have thought of acquiring that company and making it as a proprietary software to sell. But all those calculations go for a toss if there is open source and there is non-compliance there. So there are methodologies.
Great. We'll discuss that offline, but basically you're suggesting that it could be a condition subsequent. You're also saying that partial hold on the consideration?
Yes.
Got it.
Because we have to take care of our company's interest also. It has to be a balance between the interest of the seller and the buyer. And the time consideration, the cost consideration, all these factors has to be factored in.
Okay. Any another question?
Like, how does one get compensated for the cost incurred for the building up of the IP in exchange of giving it to the open source?
I can give you the best example of Android versus iOS, or Tesla or Toyota open sourcing their. So, since you are a person with economics background, at one side, let's say it's proprietary. The adoption level, because there is a cost. Here, you only have to do compliance. You have freedom to use, but you have to comply with in open source. At the same time, the number of users is much higher in open source. That's why I gave the example of Android. iOS, how many percentage of the global population uses it? But it doesn't mean that Android users, providers like Google is not making money. The concept is called co-option, cooperation on the fundamental technology. so that everybody uses it. On the other hand, you make money from the implementation of that technology. So that's why Tesla has open sourced their EV platform patents. For a simple reason, because if they had put a restriction or the cost, there will be no adoption of Tesla's EV technologies or patents. And they would make money if more people adopt their technology, use their technology. So from that perspective and a cost perspective, you can scale open source. There is a limit to scale proprietary software. And it's like you are bound by it. You are a slave of proprietary software. Because you can't move. Here there is a freedom to operate. Okay, this project, you are not happy with this open source project, you can move to another open source project. Nobody can, in a proprietary software, people can put you on gunpoint. I think you remember a few days back, a few months back, we had an issue where there was a global outage of CloudStrike and Microsoft was related to it. So airports, flights could not take off. All this was because of proprietary usage. In case of a open source, there are people across the globe who can contribute to it. But in case of a proprietary entity, it is only those entity guys because nobody has access to the code. So from an economic perspective, from a global contribution perspective, from every adoption perspective, from a business perspective, because it is cooperation on the fundamental technology and open source, but there is more adoption, more usage, and there is a competition on the services you provide. So you make money from the services. So it has a business sense, it has an economic sense, it's more democratic. It is not monopolistic.
Okay, thank you all for your patience.
Thank you, panel members, for that wonderful discussion on managing IP risk and mitigation. I'd like to call upon Mr. Vinayak from Bajaj Electricals to felicitate our panel members, starting off with Mr. Aditya Patil from Polaris Incorporated. Next, we have Mr. Biju Nair from Open Innovation Network. And then Ms. Taruna Gupta from TCS. We have Dr. Agarwal, Honorable Founder and Director of GIPC with us in the room, so I'd like to invite him to stage to honor Mr. Vinayak from Bajaj Electricals. All panel members kindly assemble for a group photograph. Thank you. Now we shall take a quick break of 20 minutes and reconvene with the next session at 3:50 p.m. Thank you.